The Federal Mediation and Conciliation Service recently had its first in-person national conference since before the pandemic, which got us thinking, what's it like on the ground in the world of labor relations in the United States? So for an update, we turn to the FMCS Deputy Director for Field Operations, Javier Ramirez. Mr. Ramirez, good to have you with us.
Yeah, good morning, Tom.
And just briefly, so in case there's a few people out there that may not know exactly what the Federal Mediation and Conciliation Service does.
So we were created in 1947 primarily to help with the large amount of strikes that were happening after World War II. So we were created primarily for the private sector, but as the Congress saw the work that we do in dispute resolution, they gradually started to expand our authority. And so in 76, under the Civil Service Reform Act is when we started to do federal sector collective bargaining. Then in the 90s, under the Administrative Dispute Resolution Act, we started to do additional work for other federal agencies through interagency agreements. So basically dispute resolution, give us a call. If we can't help you out, we'll point you in the right direction.
And so how do you interact vis-a-vis the FLRA, the Federal Labor Relations Authority?
So the FLRA, they're separate. And so what happens is they have a number of arms there in the FLRA, but we work really nicely with them. We specifically work with CADRO,
the Collaboration and Alternative Dispute Resolution Office,
that they handle negotiability claims. So when folks are negotiating their collective bargaining agreement and they're not sure if this is a permissive subject of bargaining, they usually go before the CADRO, and then they will help them either mediate that and or resolve that issue. And so we work really closely with them. They also do training programs to help with federal sector folks, and we sometimes partner with them to do those. And interestingly enough, before cases go to the Federal Services Impasse Panel, which is part of the Federal Labor Relations Authority, they have to go through mediation. So although they're not required to use our services, they could use a private mediator. Our price is kind of hard to beat, right? So we don't charge federal agencies. So the majority do come through us.
But you still do commercial, industrial, private sector mediation also.
That is the bulk of our work. And if I'm being candid with this federal crowd, we could have done better in servicing the federal sector workforce. And we learned that when we send somebody over to the Federal Services Impasse Panel to work with them for 6 months. They came back and gave us a report out on stuff that they saw that we could be doing better, and we implemented those changes. And so when we implemented those changes in a matter of 3 months, we went from resolving disputes, about half of them, these cases that came to us, from 50% to 80% resolution rates. And the number of issues that moved forward to the Federal Services Impasse Panel went from dozens to 2 or 3. So dramatic changes in the federal sector there.
And what does the workload of the conciliation service look like? Do you do thousands of cases a year, hundreds, dozens? What's the order of magnitude?
Yeah, so tens of thousands. And I say that as a whole, right? Because there's a number of type of cases that we handle. But federal sector collective bargaining, we're in the range of about 200 plus or minus 50 that we handle in a given year before they go to the panel. But we get in the private sector, we get about 15,000 notices a year of contracts that are expiring. And that's not including grievance mediations, public sector, when we do teachers, police, fire, we just help out on those as well. So our volume is pretty high.
Yeah, and so mainly then the work is when a contract is expiring or has expired, negotiations aren't finished, and they seem to be going nowhere, and people are on the verge of possibly a strike. That's when you tend to come in.
Yeah, you know what? The Labor Management Cooperation Act was an amendment to the National Labor Relations Act, and that act asks us to start trying to do stuff before that situation occurs, right? So we'll go in there and during midterm bargaining, or the middle of the negotiations rather, we will come in and do training programs to help them communicate more effectively, resolve disputes more effectively, and to establish labor management committees and just good communication processes so they could avoid the battle when it comes to negotiations.
Right. Trust is kind of a big factor in having these things go well, isn't it?
I tell people you don't necessarily have to trust each other, but trust the process. And sometimes we help them honor the process so they could trust the process and use that to reach agreement, even though there may be some trust issues within the relationship.
We're speaking with Javier Ramirez, Deputy Director for Field Operations at the Federal Mediation and Conciliation Service. And in the federal disputes that you take care of, are there any themes, any trends? I mean, what happens to cause an impasse the most often have you seen?
Yeah, as far as in the federal space, the number one issue that we're seeing right now is return to office. And I'm very careful with that term, right? It's not return to work. The federal sector has proven that we could be very effective working from home. But we understand that depending on the type of role that they're doing, that there is a need for a return to office situations. So it's that battle back and forth of what's the appropriate amount of office time versus working from home time. And that seems to be the number one issue that we're seeing in the federal space at the moment.
Well, does it have to have been something in a contract or a labor agreement clause in order to come before the commission? Because otherwise it's simply agency management discretion, correct?
Sure. Unless there is a collective bargaining agreement.
Right.
And if collective bargaining agreement, then yeah, that would be something that they have to negotiate with their union.
And what do you find that there somewhere is cutting the baby in the middle? That is to say, some people might want to telework all the time. The agency, just to make an extreme, the agency may want people to come in 5 days a week plus Saturday morning. So you have to find some way in the middle of that.
Yeah, each case is very unique because in some cases we've found that a lot of federal agencies have actually given back office space because of budget restraints. And so sometimes there just isn't a sufficient infrastructure to support everybody coming back. Then you have to look at the work that they're doing, security levels. Some folks during pandemic had to either come in or not do any work because of their security issues. So it really depends on the work that they're doing and the resources available, but they're all over the place. We're not seeing a standard resolution for this issue.
Sure. And let's talk about the FMCS itself for a minute. How many people do you have that are actually in the mediation business? And what kinds of skills do those people need to have?
On the whole, the number of mediators that we have about 120, 130 mediators. They all do work within the federal sector in regards to training, employment mediation cases, some of that work like that. When it comes to the collective bargaining mediation, that was one of the changes that we made after we had our detail with the Federal Services Impasse Panel, where we've reduced the number of mediators that handle collective bargaining in the federal space and gave them specialized training so that way they could better service the federal space when it comes to collective bargaining. So we have about 130 mediators in total that handle it. However, the skills, and one of the things that we did, and it was primarily because of the work in the federal sector, was we realized that we had to move from an instinctual practice to an intentional practice, right? Many of our mediators come in and they help resolve a dispute, and you'll ask them, so what did you do? What techniques did you use to help the parties reach that resolution? And we were finding that many of them were like, I'm not sure. I just did it, right? And so we want to move from that instinctual practice to intentional, where they might be able to see the dynamic, put a name to it, and understand that when we see this behavior, these are some skills or techniques that we could apply when we see that. We're calling that our conflict management professionals program, and we've implemented that a couple of years ago, and we're training up all our mediators on these conflict management professional skills. You see that going into the private sector also.
Because often they don't have a legal reference. That is to say, the cases aren't the same as in nature as what might become, before the Merit Systems Protection Board, for example, where there's a legal kind of true north that they're measuring against, statutory language. In this case, it's what's really right here for the situation.
Yeah, exactly. What's right and what are the parties willing to accept? And unless we see something that we know is glaringly illegal, or we would say, hey, you may want to check with your counsel before you sign off on this thing, right? Because we don't give legal advice. We're non-enforcement. We're non-regulatory. We're there truly to just help the parties resolve disputes. As a matter of fact, one of the things I tell our folks is that your job is to try to put us out of business, right? Unfortunately, we're in a growth industry and there's no shortage of conflict. Wouldn't it be nice if we ended up putting ourselves out of business, right? It's not going to happen, but that's the mindset. Put us out of business.
And if people don't accept the mediation, then they can always go to court. How often does that happen?
So with collective bargaining, it's a little different because you have the Federal Services Impasse Panel that they would go to. In the private sector, you have strikes. There are occasions where they can do arbitration. But in other disputes, like employment mediation cases, then they could go to the next steps, whether it be with the EEOC or some other agency, depending on what the issue is, where they would do that. But our resolution rates, and I would need to check on this to be sure, but it's in that 80% ballpark range.
All right. And just briefly, how did you come to this work? Tell us a little bit about yourself.
Yeah, you know what? Our mediators in general, we get them from one of four sources. We get some that come from other federal agencies like the National Labor Relations Board, or maybe they're